Good morning, everybody. I am back again, and I am your host, the Supreme Litigant. Y'all already know the routine. Before I get into it, hit that subscription button and pound that like button if you haven't already. I'll give y'all a second to do that. All right, let me jump right into this. So today I want to talk about how to type a motion to dismiss. But before I get into that, I'm going to explain to you the purpose of a motion to dismiss with these cases on my YouTube channel. So when you file a motion to dismiss, you are basically demurring. So a demur is an antiquated term for a motion to dismiss. Now, if you look at this term antiquated, you can see that it seems to me it's like a variation of the word antique. So basically, a demur is an old way of saying motion to dismiss. Okay, that's basically what it is. Just another way for saying a motion to dismiss. And the purpose of a motion to dismiss or a demur is to test the legal sufficiency of a pleading. So let me show y'all what I'm talking about here. So let me go here and we're going to go to, let's see, Rule 12B, whoops, B6. There we go. Standard. No, I think that's an old standard. So we're right here. Rule 12B6. And I'm explaining this to y'all. So if you file a complaint against police officers, okay, and you're saying that these police officers unlawfully arrested you and assaulted and battered you and stuff like that. Where is it six? I don't even see six in here. I must have skipped it. Give me a second, y'all. Right here. Rule 12B6. Okay. And you're saying that they unlawfully arrested you and assaulted and battered you, but you only make these allegations in a conclusory manner. Okay. You don't state the facts in support of how you came to that conclusion. When you do that, they are going to file a Rule 12B6, failure to state a claim upon which relief can be granted. And they're probably going to claim qualified immunity. The reason they're going to do that is because when you make these allegations against these police officers in a conclusory manner, you violate due process because you're not giving them facts that they can dispute to properly. Let me phrase that. You're not giving them. You're not allowing them to properly litigate this case. If that makes sense, it's probably going to confuse y'all a little, but it doesn't confuse me. But hopefully y'all will get what I'm saying. They're going to file a Rule 12B6 motion to dismiss, which would be the right thing to do, and it's going to get granted because you didn't state facts. It's always about the facts. I've always told y'all that it's always about the facts, and that works the same exact way on the criminal side. Just to let y'all know. Let me go back here. Let's go up some more. Now here's a case. This is a case right here. I edit this to kind of make it better for everybody to understand. So a demur, also called a motion to dismiss, tests the legal sufficiency of a pleading, i.e. complaint. The demur is sustained only if it fails to state a valid cause of action or criminal offense. So if these police officers, they pull you over and they say you did disorderly conduct, they're arresting you for disorderly conduct, but they don't state facts and how they came to the conclusion of you committing the alleged so-called crime of disorderly conduct, then what you do is you demur. You file a motion to dismiss. And you explain to the so-called court why you are filing this motion to dismiss. This is something that I would say. The complaint is vague, it's conclusory, it's legally insufficient as a matter of law. It is devoid of the prerequisite elements of the offense. So on and so forth like that. That is something that I would say. Let's go up a little bit more. At the outset, let's go back up here. At the outset, it is well to mention some of the elementary rules concerning the place and scope of a demur. And this is American jurisprudence, blah, blah, blah. A demur is the method of raising an objection to the sufficiency in a pleading in a let me rephrase that, to the sufficiency in law of a pleading. So basically what you're saying is you're saying that their complaint against you, whether it be civil or so-called criminal, is legally insufficient as a matter of law. That is what you're saying when you're filing a demur or when you're filing a motion to dismiss. That's what you're saying. It may be filed either by the plaintiff or the defendant to test the other's pleadings for defects therein apparent on the face of such pleadings. A demur does not raise any questions of fact or a mixed question of law and fact, but questions the law, but questions of law only. And it is erroneous for the court in passing on the demur to determine a disputed question of fact. I'm going to go up some more. A demur tests the legal sufficiency of a pleading. The absence of any allegation essential to a cause of action or an offense or a so-called crime renders it vulnerable to a general demur. A ruling on a general demur is thus a method of deciding the merits of the case on the assumed facts without a trial. A judgment entered after a general demur has been sustained is a judgment on the merits to the extent that it adjudicates that the facts alleged do not constitute a cause of action. Let me read that again. I'm going to read it in another way, though. That the facts alleged do not constitute an offense. They call it an offense in a criminal case, or do not constitute the crime or blah, 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 whatever. And will accordingly be a bar to a subsequent action alleging the same facts. So this is on the so-called civil side. Okay, and what they call it on the civil side is a res judicata. That's what they call it, a judicata, adjudicator, whatever, on the civil side. But on the criminal side, guess what they call it, y'all? Y'all probably already know. Double jeopardy. This is the same exact shit. They just calling it different shit, y'all. This is the same shit what they doing, y'all. It's the same shit. Do not let these people confuse y'all. They are not smarter than you. They just read. That is it. That's it. So let me get into the basically how to type a motion to dismiss. It's pretty much the same thing, y'all. It's just pretty much the same thing. I would use, and I'm just freestyling this. This is going to be real quick. So I'm just going to freestyle this. Let me go back here. And I'm going to use this one from American Jurisprudence right here. I'm gonna get all that. I'm not even going to copy this. Well, yeah, you know what? I will, because it's from American Jurisprudence. So I can copy that. I'll copy that. And we'll go here. And this is all you're doing. You're going to change this to this. I like that. That don't seem like it's dark enough for me. So let me go and fix that color. That's better. Okay. We're going to edit this footnote. Where's that footnote at? Right here. We're going to edit the footnote. I would go so far. Let me put that up there. Yeah, we'll do it like that. We'll make it a little smaller. Fix this on up. Times, let's make that probably about 11. Yeah, we'll make that into 11. All right, boom. We're going to bold that. Do it like that. Motion to dismiss. And we still going to be here on a special appearance. Hereinafter, the alleged defendant under duress to motion to dismiss. Let's see. Pursuant to, and since this is in state court, we're going to say pursuant to the 14th. Whoops. Due process clause. Yeah, we'll say pursuant to the 14th Amendment's due process clause, because they have to. Well, you really don't even have to do that. You can do it if you're in Alabama. You can do it under Article 1, Section 6, because the in all criminal prosecutions, the accused has a right to be informed of the nature and cause, and they're doing this in a yeah. We'll do it under the Alabama Constitution, and I'll show y'all what I'm talking about. This is how I do my stuff. We don't even have to do it like that. We're gonna go to Alabama Constitution 1901. Should be section. I think it's Article 1, Section 6. Rights of person in criminal prosecution. Yeah, even though it's not criminal, it's quasi criminal. It's not criminal, but you know this is what they like to do. Yeah, that's right. Yeah. All right, let's go. We'll say pursuant to Article 1. Where's that sign at? I like to get that sign. I like my stuff to look good, y'all. Let me. Let's see if I can find it. If I can't find it, I ain't gonna worry about it. Let's go back. Probably ain't gonna find it. All right, I don't want to make the video too long, so I'll do it this way. Article 1, Section 6. Because they're not informing you of the nature and cause of the action. Let's see. They're not giving you the facts. Article 1, Section 6. To dismiss. We're going to say, we're going to want to dismiss it with prejudice under these set of facts. To dismiss with prejudice. The instant case. The instant case. What else we going? So I'm trying to see if we can do it like for violate. Sometimes this stuff it might take a little time, y'all, but it's real easy. It is real easy. So like you can leave this in support of this motion. You can leave that right there. The alleged defendant averts the following. You can leave that right there. When you're doing a motion to dismiss, I would not type any affidavit at all. I would not give them an affidavit at all, because the reason why I wouldn't give them one is because they already don't have the facts that they need. So why would you give them an affidavit testifying to what actually happened? I would not do that at all. Period. You don't make their case for them. You make them do their own. You let them do their own job. Don't make their case for them. Let them do it. Let them do what they're supposed to do. Let me see. Pursuant to Article 1, Section 6 to, let me see. I forgot this. Nineteen oh one to dismiss with prejudice the instant case as, yeah, we'll say to dismiss the instant case. You can do it like that. You don't even have to do this. And you can just go right up here. You can delete all of this. In support of this motion, the alleged defendant diverts the following grounds. You can say something like the complaint is patently. I'm gonna make this simple because I speak in their language very well to a certain extent, but I'm gonna make this very simple for y'all. It's clearly frivolous. It's clearly frivolous. Well, let me change that around. The complaint is, this is my favorite right here. Devoid of the prerequisite elements of the offense, vague, conclusory, because they always do this, y'all. They always do this. Conclusory and legally insufficient as a matter of law. That's one of them. Now, what you would do, if I got a complaint that it was just nothing but conclusions, this would probably be the only thing that I would type in this in my motion to dismiss. The complaint is devoid of the prerequisite elements of the offense, vague, conclusory, and legally insufficient as a matter of law. That would probably be the only thing that I would type in there. Unless not, if they might try to test you out a little bit and may want you to put something else in there. But until they do that, I would not. Me personally, I wouldn't type anything else. How I'm feeling right now, I wouldn't type anything else. To dismiss with prejudice the instant case. Yeah, okay. So what you're trying to do is this, y'all. Let me go back up and show this to y'all. You're trying to get this case dismissed with prejudice on the facts that they have now before the court. Not under a different set of facts, but under the facts that they have now, because you're saying that these facts are legally insufficient as a matter of law. Once you do that, they cannot bring that same set of facts and use it again to try to procreate these so-called criminal charges against you, because that will be in a so-called criminal case, that will be double jeopardy. It will be the same thing in a civil case. If you did, if you drafted, a lawsuit against police officers under some facts, and the court has ruled on these facts and said these facts are legally insufficient as a matter of law, you cannot bring those same set of facts back before that court and try to bring a lawsuit against those police officers. That would be a res judicata, which is an affirmative defense. They're going to plead that as affirmative defense, or so on and so forth. But anyway, hopefully this stuff just makes sense for y'all to understand. This stuff is not hard, y'all. It is not hard at all. It ain't hard at all. Now I'm going to go back here and I'm going to read y'all some more stuff, because I really want y'all to understand what I'm trying to get y'all to understand. Let's see. This is a New York case. A complaint is dismissible if it contains conclusory statements or insufficient evidentiary facts. A complaint which contains allegations that a deponent police officer, or, as in the instant case, a court officer observed the defendant in the possession of an electronic stun gun, is facially sufficient. Let's go down some more. I'm going to read these right here that are in blue. Conclusory allegations are insufficient, and where the factual portions fails to establish every element of the offense charged, a motion to dismiss for facial insufficiency must be granted. It's always about the facts. It's always about the facts. So remember, y'all, all so-called crimes have elements, okay? And if they fail to allege one of these elements against you when they bring these so-called criminal charges against you, and this particular element is essential, that element is essential to justify that conviction or material to justify that conviction, but they never alleged it, then a motion to dismiss should be granted. You should file a motion to dismiss on that. But if you want to know the elements of the so-called crimes, you're going to have to read cases. That is what you're going to have to do. You are going to have to read cases. Such conclusory pleadings is insufficient to defeat a motion to dismiss. Motion to dismiss the complaint as legally insufficient is granted. Legally insufficient, but you have to explain. You can't just say it's legally insufficient because that's conclusory. You have to explain to them why it is legally insufficient. So back to in considering that now, I probably would just put a little bit. Well, I think I did. The complaint is devoid of the prerequisite elements of that's enough. That's enough because a good so-called judge is going to know what you're talking about when you put that in your complaint. And they always do this, y'all. They always allege conclusions. They never allege facts. It's very rare that they allege facts. They always do it in a conclusory manner. Let's see. Right here. A motion to dismiss a criminal charge should be denied when the complaint is valid on its face. If it's valid, it's not going to be denied. Such bare bones and legally conclusory allegations are insufficient to survive a motion to dismiss. To withstand a motion to dismiss, speculative and conclusory allegations are insufficient. Always about the facts, y'all. It is always about the facts. Always. So let's see. Comes now John Doe hereinafter the alleged defendant on a special appearance and under duress pursuant to Article 1, Section 6 of the Alabama Constitution to dismiss with prejudice the instant case. We're going to say for failure to give fair notice, we're going to say for failure to inform the alleged defendant of the cause in the manner mandated by due process. That's what we're going to say. Mandated by due process. Something like that. That's pretty good. It's pretty good. In support of this motion, the alleged defendant avers the following grounds. And then you just go on and so forth. If you have something else you want to say, you put it in at number 2. If you got something else you want to say, you go down to number 3 and so on and so forth. Let's get this out of here. This is something old. And that's it, y'all. That's all you do, man. That is all you do. That is all you do. Now, if you're in a federal case and you are litigating a civil rights lawsuit, if it's a so-called civil case, then obviously you would use Rule 12b-6, the rule that I just showed y'all, the motion to dismiss. If you are a defendant in that case, you would use a 12b-6 and you would explain to the court why you are filing the motion to dismiss, so on and so forth. It's the same shit, y'all. It is the same exact shit. That's it, y'all. That is it. That's it. You're filing a demur, or aka a motion to dismiss, because the complaint is legally, you're testing the legal sufficiency of the allegations against you. That is all you're doing when you file a demur, aka motion to dismiss. What the so-called judge is going to do is they're going to accept all of the allegations that are pled against you as true. And they are going to take the relevant case law and apply that case law to those set of facts to determine if those facts are legally sufficient as a matter of law or legally insufficient as a matter of law. If they're sufficient, then you can sustain the cause of action against them. If they're not sufficient, then the cause of action's got to be dismissed. Simple. Same thing with a criminal charge. If the complaint against you in a so-called criminal case is legally sufficient, then the charges are going, you'll go to trial, probably get convicted, go to jail or whatever. If they're not, motion to dismiss. They gone. And they can't bring those charges back up against you on those same set of facts. They have to do it under a different set of facts. Same shit, y'all. Same thing. Hopefully this made sense for y'all. If y'all need me to try to explain it to y'all better, just let me know. And we'll just go from there. The Supreme Litigant is out. Peace.